The Law of Obligations. Introduction. Welcome to Module 2 of ACCA F4 Corporate and Business Law, focusing on the law of obligations. In this video, we will explore the concept of legal obligations, essential elements of a valid contract, key concepts of offer, acceptance, consideration, and intention, contractual capacity and privity, breaches of contract and available remedies, basic calculations in contractual damages. What is an obligation in law? A legal obligation is a duty enforceable by law. Legal obligations arise primarily from two sources: contracts, an agreement creating legally binding duties between parties; torts, a civil wrong such as negligence that causes harm to another person. Understanding these obligations is fundamental to business law. Essentials of a valid contract. For a contract to be legally enforceable, it must contain 6 essential elements: offer and acceptance, consideration, intention to create legal relations, legal capacity, certainty of terms, legality. Each element must be present for the contract to be valid and binding. Offer versus invitation to treat. It's crucial to distinguish between these two concepts. Offer. A clear proposal by one party, intended to be binding upon acceptance. Creates legal obligations when accepted. Invitation to treat. An invitation to negotiate or make offers. Not binding. Examples include goods displayed on shelves or advertisements. Acceptance. Acceptance is the unqualified agreement to all terms of the offer. Acceptance must be communicated to the offeror, made while the offer is still open, made by the party to whom the offer was directed. Methods of acceptance include verbal communication, written communication, conduct that demonstrates acceptance, consideration. Consideration is something of value exchanged between parties. Key principles. Must be sufficient but not necessarily adequate. Must move from the promise. Cannot be past consideration. Example: A agrees to sell a laptop to B for $400. B's consideration equals $400, the money. A's consideration equals laptop, the goods. Intention to create legal relations. The law makes certain presumptions about intention. Business agreements. Presumed to be legally binding. Parties intend legal consequences. Social or domestic agreements. Presumed not to be legally binding. Example: a promise to take a friend to dinner is not enforceable. These presumptions can be rebutted with evidence. Legal capacity. All parties to a contract must have the legal capacity to contract. Parties lack capacity if they are minors, under 18 in many jurisdictions, mentally incapacitated at the time of contracting, intoxicated to a degree that impairs judgment. Contracts with parties lacking capacity may be void or voidable. Privity of contract. The doctrine of privity states that only parties to a contract can enforce or be bound by it. Key points. Third parties generally have no rights or obligations under the contract. Third parties cannot sue for breach of contract. Exception. Statutory exceptions exist, such as the Contracts, Rights of Third Parties, Act 1999 in the UK. Terms of a contract. Contract terms are classified into different categories. Express terms. Clearly stated in the contract. Agreed upon by both parties. Implied terms. Inferred by law or conduct. Not explicitly stated but understood to exist. Classification by importance. Conditions, Fundamental terms: breach allows contract termination. Warranties: lesser terms: breach allows claim for damages only. Vitiating factors: certain factors may invalidate an otherwise valid contract. Misrepresentation: false statements inducing contract formation. Mistake: fundamental errors affecting consent. Duress: pressure or threats forcing agreement. Undue influence: exploitation of trust or authority. Illegality: contracts for illegal purposes. Discharge of contract: a contract may come to an end through four main methods. Performance: all duties have been completed satisfactorily. Agreement: mutual decision by parties to end the contract. Frustration: unforeseeable events make performance impossible. Breach: one party fails to fulfill their obligations. Breach of contract: breach occurs when a party fails to perform their contractual obligations. Types of breach: refusal to perform contracted duties. Defective or incomplete performance. Failure to perform on time. The remedy available depends on whether it's a breach of condition or warranty. Remedies for breach: several remedies are available for breach of contract. Damages: monetary compensation for losses suffered. Specific performance: court order requiring actual performance of the contract. Injunction: court order preventing a party from certain actions. Rescission: cancellation of the contract, returning parties to pre-contract position. Damages basic math example. Calculating damages involves determining the financial loss. Example scenario: contract price equals $1,000. Market price after breach equals $750. Legal costs equals $200. Calculation: direct loss equals $1,000 to $750 equals $250. Total compensation equals $250 plus $200 equals $450. This represents the amount needed to put the innocent party in the position they would have been in if the contract had been performed. Tort versus contract comparison. Understanding the differences between tort and contract law. Relationship: contract, based on voluntary agreement. Tort, no prior relationship needed. Duty: contract, voluntarily assumed obligations. Tort, duties imposed by law. Remedy: contract, compensation for expectation loss. Tort, compensation for actual harm suffered. Practical application. Let's apply our knowledge to a real scenario. Situation: a contractor fails to deliver materials as agreed. Client must hire another supplier at higher cost. Loss calculation: original contract price, $5,000. Replacement supplier cost, $6,200. Direct loss equals $6,200 to $5,000 equals $1,200. Legal costs equals $500. Total claim equals $1,200 plus $500 equals $1,700. Conclusion: we have comprehensively covered the law of obligations. Legal obligations arise from contracts and torts. Valid contracts require offer, acceptance, consideration, and intention to create legal relations. Various factors can invalidate contracts. Breaches lead to specific remedies including damages and specific performance. Mathematical calculations help determine appropriate compensation. This knowledge forms the foundation for understanding more complex business relationships and legal obligations. Thank you for joining us for this detailed exploration of the law of obligations.